Well, good morning, everybody. It's 10 a.m. and that is our designated start time. So we want to get rolling and because we have a lot to cover in this morning's webinar. Glad you could join us. Hope everybody is staying dry and safe during this relatively miserable Michigan week, weather-wise. Hope everybody is doing well, and we appreciate you joining us this morning. It seems fitting that as we sit here on what is officially the last day of the school year, that it's kind of like every time you think you're out, they draw you back in, or but wait, there's more kind of feeling. We wanted to do one more round of professional development before the official summer break, July 1. And it's been obviously a very eventful year. It seems apropos that in a very eventful year, we've had a very eventful couple of weeks here in terms of legal developments, and so important, and so many really necessary issues to discuss. We know everybody's looking forward to some downtime and some rejuvenation during the month of July, but we thought one more round of PD would be appropriate. And so very pleased that we'll be talking about these three really important topics this morning, all of which have really come to fruition in the last handful of days. First, we're going to talk about the updated COVID-19 rules, guidance, maybe suggestions, and its application to schools. And I know there's a lot of questions about that. Secondly, we're going to talk about the off-campus speech in light of the Supreme Court's recent ruling. Probably heard about it in the papers, saw it on the news. A lot to unpack there. And then last, we're going to talk about a Title IX update, which sounds pretty straightforward, but there's been a lot that has happened on that front. And so we're going to mix it up a little bit today. Cathy Tracey is going to lead off with COVID-19. Bob Schindler is going to talk about the Supreme Court case, and then I'll be handling Title IX. So with that, Cathy, I know you got a lot to cover. We will turn it over to you.
All right, thanks, Kevin. Good morning, everybody. First, I have to apologize, which I don't usually like to do when I provide a presentation, but I think I do have to apologize to all of you that you have to sit through yet another presentation on COVID. Who would have thought back in March of 2020 that we would be entering our second school year needing to think about COVID-19 protocols, but that's where we are, so let's get to it. As of the end of last school year, schools' legal obligations related to COVID safety protocols largely derive from three primary sources: MIOSHA, MDHHS, and local health departments. As all of you, I'm sure, have heard, which is why in part you are on this call, effective June 22nd, both the MIOSHA rule and the MDHHS order have been withdrawn. So let's talk about where that leaves us. So the MDHHS order, the most recent one as of June of 2021, still required that unvaccinated individuals, when gathering indoors, had to wear masks, which would, of course, include all students under the age of 12 because they can't be vaccinated. It also required us to comply with testing protocols stated in MDHHS's interim guidance on athletics. And as I'm sure you've experienced, the athletics phone calls are some of the most frequent and forceful. So those were requirements that we had as of June 22nd, and they are no more. But when MDHHS rescinded that order, they did warn in their statement that local health departments, establishments, sports organizers, and school districts may have additional rules that must be followed. That brings us to last Friday. So last Friday, MDHHS issued interim recommendations for operating schools safely when there is COVID-19 transmission. You'll see on my slide that recommendations is highlighted in red. That is my highlighting, that is not MDHHS's highlighting. And that's just to emphasize what Kevin sort of alluded to in the introduction. These are recommendations. There is no independent legal force behind them. So you are not required to comply with them by MDHHS, but we'll get to some of the other reasons why you may adopt some or all of them a little later. So what is this guidance? Basically the MDHHS promotes a layered defense against COVID-19 in schools. One thing they're asking schools to do is promote vaccination for eligible students and staff. They don't define what they mean by promoting vaccination. That could be, the school taking an affirmative stance that vaccination is a good thing. It could mean that schools promote opportunities for students and staff members to get vaccinated by offering clinics in conjunction with local health departments or things of that nature. The rest of the recommendations are largely the things that you guys have been doing all year or all last year, with some less specificity, I suppose. So the one thing that was in all the media reports is that the recommendation is to continue using face masks, consistent with CDC recommendations. There's a recommendation to continue social distancing, which includes physically distancing within the school and cohorting of students. The recommendation is that you would continue your COVID screening, that you would continue to encourage testing of staff and students who are symptomatic or who have had close contact with someone who tests positive and who are unvaccinated. They encourage you to continue contact tracing in collaboration with local health departments. And they're also encouraging schools to maintain healthy environments. That includes teaching good hygiene practices. It includes routine cleaning that we've been doing, and avoiding crowded or poorly ventilated indoor spaces and activities. And all of these things MDHHS recommends we implement while considering what the level of COVID transmission is in the community. So the degree to which we would implement some of these recommendations will depend on, how, what the current spread is, both I would say in a building and in the community generally. So let's turn to MIOSHA. The other rule that was rescinded was that MIOSHA rule that we have been subject to since last October and has become very familiar. As you recall, that rule contained a laundry list of very specific requirements that employers, including schools, had to adhere to in order to meet its obligation of providing a safe workplace. That included, your COVID-19 preparedness plan, basic infection prevention measures, health surveillance protocols, workplace controls, specific training obligations, and specific record-keeping obligations. Those are all gone. But in its place, there still are remaining workplace obligations. So two of our partners, Sandy Andre and Sarah Willie, did an entire webinar last week on the sort of where we stand currently with MIOSHA, which I'd encourage you to tune into for a deep dive. But I wanted to flag a few things here. One is that MIOSHA's existing standards, the ones that we were adhering to back in September and before, still apply. One of those that was specific to COVID was, when there's a workplace exposure, or if someone tests positive or if an employee tests positive for COVID, we would have to determine whether there was a workplace exposure, and if so, document that and report it appropriately. So we still have that obligation. We also have an obligation under MIOSHA's general duty clause to provide a place of employment to our employees that's free from recognized hazards that are causing or likely to cause death or serious physical harm to the employee. This is what we were operating at before OSHA or MIOSHA put out their emergency rule in October. MIOSHA has taken the position that when they determine if there's sufficient evidence for a general duty clause citation, they're going to look at the employer's COVID-19 program in its entirety. And if after considering all of the measures that the employers implemented, if there's still a recognized hazard, then they will issue a general duty clause citation. So the bottom line from my perspective is that schools should really determine what they need to do in good faith to keep COVID out of the workplace and to prevent its spread. Because COVID, if you look at that enforcement guidance citation, is the recognized hazard. So that's what we're trying to keep out of the workplace. And employers now have the discretion to decide what things they need to do in order to make that happen. Another thing I wanted to flag was that if you have a school nurse or other employees who provide healthcare services at school, those employees and settings are likely covered by OSHA's recent emergency temporary standard for healthcare. So again, we did a webinar yesterday on that was about an hour long, which if you have folks who are providing those types of services, I would encourage you to listen in on for more of a deep dive. But for those healthcare folks and in those settings, there are going to be additional specific requirements, including the requirement to wear masks. And then the final thing I wanted to flag was we still have an obligation to comply with the COVID-19 Employment Rights Act, which was a Michigan law that was enacted in 2020. And basically, as you probably know, it incorporates the CDC's quarantine and isolation standards and provides protections for employees who can't work because they've tested positive for COVID, display principal symptoms of COVID, or subject to certain exceptions, have had a close contact with somebody who tests positive for COVID. So now that I've dumped all of this information on you about what's required and what's recommended, I wanted to talk briefly on how we should put all this together as you plan for a safe and hopefully a more sane 2021-22 school year. I think it's helpful to sort of consider, break it down into sort of what we have to do, what we might have to do, and what we might want to do. So the must-dos are, the legal requirements that I just talked about, the MIOSHA standards, the COVID Employment Rights Act, those sort of things. And one thing that we've learned through COVID is that things change rapidly. So I would encourage you all to stay in touch with your local health department and stay on top of legal developments as you're doing right now. So gold star for everybody on this call. The other thing to consider is what you might have to do. And the might have to do's are those things that we may need to do if we wanted to avoid liability and make sure that we're in compliance with MIOSHA's general duty clause. There have been a lot of questions about to what extent schools could have civil liability and negligence if they don't adopt the MDHHS recommendations. And I would say, for public schools, because you are entitled to governmental immunity, I think that if you are making good faith decisions about what protocols to adopt or not to adopt that are reasonably tied to keeping people safe, your risk of liability for not adopting specific protocols is going to be pretty low. And that's because there's a very high standard for liability. A plaintiff would have to prove that your decision not to implement a certain recommendation was so reckless as to demonstrate a substantial lack of concern for whether injury results to the person who is injured. And that's, that's a high standard, and I think it would be a tall order to say that deciding not to adopt a quote-unquote recommendation would meet that threshold. I think there's a greater likelihood that you could end up with a MIOSHA citation if you don't adopt some or all of the MDHHS guidance. Again, I want to emphasize that the MDHHS recommendations are not legal obligations. It's guidance. I raise that in connection with the MIOSHA standard because MIOSHA may use that guidance to help them determine whether you have met your general duty to provide a workplace free of hazards, i.e. COVID. So, some of my suggestions would be consider, and this is also true just from a general health and safety standpoint, consider adopting or continuing some of the easy protocols. What types of things haven't been unduly burdensome on your school? What types of things are not likely to cause or inflame the civil war within your communities over, some of these safety measures, and go ahead and adopt those so that when and if MIOSHA comes in to evaluate, whether you've met your general duty, you can show them that you have done some things. And then to the extent you have to make the hard decisions, like whether or not to require masks, those are the decisions, you make them in good faith. You consider the MDHHS and CDC guidance. You consider the current levels of COVID transmission in the community, and you make the decision that you think is best for your school and community. I would encourage you, as you make those decisions, to be flexible. As you've seen, and as you know, things can change rapidly, and you might make a decision not to require masks at the beginning of the school year when community spread is low, and then after a month or two, you're having spread within your elementary school. And if that happens, I think we need to be flexible in considering whether that decision might need to change. I'd also encourage you to document or at least be prepared to explain to MIOSHA why certain recommendations were not adopted. When MIOSHA was enforcing its standard on remote work, that was something that they looked at very closely. They cared more about why you required somebody to be at work instead of allowing them to work remotely than it did your final decision. So in other words, employers largely have the discretion to make the decision. They just want you to have thought about it and have a reasoned principle basis for the decision. And then finally, what might you want to do? As tremendously awful as COVID has been, there's some things that we learned and some improvements that we've made. I'd encourage you not to throw the baby out with the bathwater there, and remember that, reflect upon the things that worked. I know that we're probably, the incidents of flu were substantially down. So maybe that had to do with hygiene or whatever you think was helpful. Continue those. We also should probably consider what employees think about certain protocols continuing or ending. We've obviously seen a huge number of retirements this year and people leaving the educational field. So, and fewer coming in. So I think we need to think about both retention and recruitment in terms of, how we're going to create our protocols and procedures for keeping employees safe. And then finally, outside of any fear of liability, consider what concerns or areas of need there might be within your community that might warrant voluntarily implementing or continuing certain protocols or procedures. And that is it for me. You guys are free of COVID for the rest of the day.
Well, thank you, Kathy. For those that put things in the Q&A, as we turn to Bob Schindler now to talk about the recent First Amendment decision, Kathy will tackle the Q&A in the Q&A tab, and anything that's left over we'll talk about as a group when we finish up. But with that, why don't we pivot to Mr. Schindler, who's going to talk to us about, Schindler, I don't know, is it the Mahanoy, the Mahanoy? I'm going to call it Mahoney, the Mahoney case.
So Kevin and I have debated this. I've actually done some research, pronunciation guides online. The best I can tell, it's Mahanoy. So there you go. So we'll be talking about the Mahanoy Area School District versus BL. If anyone else on this webinar is like me and you're a First Amendment constitutional nerd, first, God help you. But secondly, last Wednesday was a very exciting day for you. I know it was for me. When I taught courses at Oakland, I used to always talk about how there are 4 cases that are school First Amendment cases that we really look to and guide us. And now we have another one. So it's exciting. So it was a big case. And obviously what the Supreme Court dealt with last week was an issue that we have been hoping the Supreme Court would deal with and give us guidance on for a long time now, which is, what do we do with off-campus online speech? And what does it look like? And where are our guardrails relative to off-campus speech? Because obviously the game has changed. And as we'll talk about, we're still relying on cases from well before the internet era. So to lay out some basics, Mahanoy Area School District versus BL was a Supreme Court decision that was issued last Wednesday, June 23rd, 2021. It is a landmark decision of the court addressing a school district's ability to address off-campus online speech of students. It upheld the decision of the Third Circuit Court of Appeals, which was that the school had violated the students' constitutional rights, but did so for very different reasons. And that's pretty significant. And we'll get more into it as we go here. Because if they had upheld the decision of the Third Circuit, I think there would have been a lot more panic amongst all of you school administrators right now. So some of the basic facts of the case, and it's one that probably all of you on this call can close your eyes and imagine very easily, because you've probably dealt with it within the last week or two. BL was a student in 9th grade at Mahanoy Area High School. She was on the JV cheerleading squad her freshman year, and at the end of her freshman year, she tried out for the varsity cheerleading squad, but didn't make the team. Coaches told her that they felt like she needed another year on JV and was offered a spot on the JV team for her sophomore year. Separately, this doesn't really matter to the case, but it'll help explain some of the snap that we're going to talk about next. She tried out for a private softball team, a club softball team, and didn't make the roster for that as well. So that weekend, she was at a local convenience store, the Cocoa Hut, as it is named, with a friend. While at this convenience store, they took some pictures, some selfies, and they snapped them out on Snapchat. So she puts it out on her Snapchat story. The first picture was of her and the student she was with standing there holding up both of their middle fingers, and it was captioned, F school, F softball, F cheer, F everything. Very uplifting message, right? And of course, it didn't say F. It had the entire word. The second picture was just a blank, but it was part of her Snapchat story, and then just said, "Love how me and another student get told we need another year of JV, but that doesn't matter to anyone else." So she snaps these two out, And the court goes into a little bit about Snapchat, which is always fun when you have the court and you have all these justices in their 70s and 80s trying to explain social media. But the court goes into talking about how, hey, Snapchat, part of its feature is, it goes out there and then it's out there for 24 hours and then it goes away when it's on one of the stories. But of course, as we've all seen before, just because something goes away doesn't mean it can't be captured. And that's what happened here. So she sends the snap out, puts it on her story. She has approximately 250 friends on Snapchat who can view these stories within that 24-hour period. Of course, there are students who then take screenshots of this, including the daughter of the cheer coach, who is one of her friends, and other students from Mahanoy Area High School, and of course other fellow students who are on the cheer squad. The daughter of the cheer coach shows it to her mom. And then what we see too is that other students, the picture begins to get spread around the student body, as these sorts of things always do, right? They can, once the screenshot happens, you can text them, you can send them around, etc. So the case talks about how there were several members of the cheerleading squad who went and talked to the coach and were, quote, visibly upset by these Snapchat pictures. What that means in terms of visibly upset, the court doesn't get too into, but that was the description, I believe, of the cheer coach. So what ends up happening is that BL is suspended from cheer for the following year. In doing so, the school relies on the cheerleading team rules, which BL signed, and which stated that participants should have respect for the school, coaches, teachers, and other teams, and that good sportsmanship will be enforced, including foul language and inappropriate gestures. The rules also prohibited negative information about cheerleading, cheerleaders, or coaches from being placed on the internet. So, and this is something that I think, and we'll get more into this at the end a little bit, but I mean, this is a major point right here, which is, I know school administrators and especially athletic directors and coaches have relied heavily over the years on athletic codes of conduct, or specific team rules that are created and signed. And so we're going to talk a little bit about where those are at, because I think a lot of folks have generally felt, or we have felt, because the constitutional protections of extracurriculars have always been limited, that goes a long way. Now we're seeing that in the First Amendment context, at least from the Supreme Court, maybe not as far as we thought. So BL and her mother sued the school district, asserting suspensions violated her First Amendment rights. Both the district court and then the Third Circuit Court of Appeals found on behalf of the students. So Mahanoy Area School District is in Pennsylvania, southwest Pennsylvania. And so it went to the district court in Pennsylvania, and then the Third Circuit Court of Appeals, which covers part of the East Coast there. The Third Circuit Court of Appeals set out a pretty bright line rule that speech occurring outside of school and off school grounds is not within the jurisdiction of the school. So that, as I was saying before, had the court upheld the Third Circuit's decision, it may have created some difficult situations for us to deal with. That case was appealed to the Supreme Court of the United States. The court then reviewed under its precedent from Tinker versus Des Moines. Now, for Tinker versus Des Moines, again, a famous case, but a case from 1969 was when the court issued Tinker. So we're talking about it's been a couple of years, and it's clearly prior to the internet age. And so as a result, the Tinker did not contemplate the things that we're currently dealing with. And so there were a couple of main points that came out of Tinker, though. One is that, the kind of one of the famous quotes out of Tinker is that students do not lose their First Amendment rights at the schoolhouse gate, right? But a point that the court relies on in this case, in quotes, is that conduct by a student in class or out of it, which for any reason, whether it stems from time, place, or type of behavior, materially disrupts classwork or involves substantial disorder or invasion of the rights of others, is not immunized by the constitutional guarantee of freedom of speech. So one of the points, and I think one of the similarities between Mahanoy and Tinker, is that in both of these cases, the court actually upholds the rights of the student. But what becomes really important is their description as to why they're upholding the rights of the student, right? So in Tinker, they uphold the rights of the student, and they talk a lot about the fact that, hey, this did not create a substantial disruption. And so what we were able to glean from that is, well, okay, if it had created a substantial disruption, then we could have, then it would have been right for the school to act. And so similarly, what we see in this case is the court says, hey, the court violated BL's constitutional rights in this situation. But then when they explain why it violated, we kind of get some of those parameters. So when we're looking at the holding in Mahanoy, there's a few things that we see that are become really important. These slides are a bit text heavy with some quotes from the court, but I think some of these quotes are really important to, again, sort of understanding where those guardrails are. Kevin, can you go back to that last one for a second real quick before you move on? So one important part that we know is the court says that the school's regulatory interests remain significant in some off-campus circumstances. So again, not all off-campus speech is within the jurisdiction of the schools, but just because it's off campus doesn't mean it's immunized. There are places where the school's regulatory interests remain significant. Okay, now you can go ahead. So one of the things that the court here says is the times when the school's interests remain significant, quote, include serious or severe bullying or harassment targeting particular individuals, threats aimed at teachers or other students, the failure to follow rules concerning lessons, the writing of papers, the use of computers, or participation in other online school activities, in breaches of school security devices, including material maintained within school computers. So this quote is probably one of the most solid pieces of guidance that we have in the case, right? What we know is the court is saying if the speech had fallen into one of these areas here, then it would have been actionable because it would have remained within the significant school interest. The court goes on to explain that it can sometimes be difficult to ascertain when speech is off campus versus on campus. And further, that there are a myriad of situations in which speech that is off campus would trigger the ability to act on student speech. And the court is not trying to define all such situations and speech. So in other words, it gives this quote about when interest remains significant, but then acknowledges the idea that, hey, there's still some things to be figured out. And this is not an exhaustive list. So we're still going to have to figure some of this out as we go. But at the very least, we have this particular situation. In terms of the on-campus versus off-campus, the court talks a bit about that as well. And as it says in here, we do not now set forth a broad, highly general First Amendment rule stating just what counts as off-campus speech, and whether or how ordinary First Amendment standards must give way off campus to a school's special interest or special need to prevent substantial disruption of learning related activities or the protection of those who make up a school community. As far as this on campus versus off campus, the court gets into a lot of what we think of already in the school world as sort of the at school versus not at school. So the court acknowledges the fact that, off campus doesn't necessarily mean that if, you're at the at the school all night party that's held off site, you're not on campus, but you're still, that wouldn't count as sort of the normal off-campus type speech, right? Similarly, if you're at a school sporting event with your team, or you're on the bus to and from, etc. And these are things that we in the school world generally think of as at school already anyway, and the court sort of acknowledges that. The court also notes that the school itself has an interest in protecting a student's unpopular expression, especially when the expression takes place off campus. America's public schools are the nurseries of democracy. Our representative democracy only works if we protect the marketplace of ideas. So this court has been strong on First Amendment rights, and it continues to do so. And what it talks about is, while there is the ability to reach out and deal with issues that occur off campus, that ability becomes limited when we're talking about off-campus speech, and that the mere stating of unpopular opinions is not enough for schools to take action. So the court goes on to note that BL's speech, while crude, merely amounted to criticisms of the world of which she is a part. The speech did not contain fighting words. While crude, it was not obscene, as the court has defined that in other cases, and it cites to some cases. It did not identify the school or target any member of the school community. Because again, if you think back to the tweet, it doesn't mention Mahanoy Area High School. It doesn't mention the cheer coaches, but specifically by name. It just sort of says to F all of them, right? All school, all cheer, all softball, etc. So the court notes that the speech was of a variety that, quote, were she an adult, the First Amendment would provide strong protection. The school expressed, so then the court also gets into some of the areas where it finds limitation in this case, right? And it says the school expressed an interest in teaching good manners and punishing vulgar language aimed at the school community. That was one of the basis for their discipline. And the court notes, well, one, she was on her own time. This wasn't a situation where she was in any school-related activity. The school was not standing in loco parentis. This is a phrase that we've probably all heard before, but in loco parentis is the Latin phrase, which essentially means that the school would be standing in the shoes of the parents. And so in that situation, this wasn't a spot where the school was, when she made the speech, wasn't in control of the student in an in loco parentis manner. And that the school also presented no evidence of generally attempting to prevent vulgarity outside of school, which I think was an interesting point that the court raises. They're gonna cite to the fact that they're trying to deal with vulgarity, and the court says, well, you didn't present any evidence. I'm sure this isn't the first student who's sworn online outside of school. And there's no evidence that anyone else has ever been dealt with in this. So in other words, what the court is saying, although not specifically saying, is, well, in this case, you don't like the vulgarity because you don't like what she's saying, versus the mere fact that you're trying to prevent vulgarity in general. The school further expressed it was attempting to prevent disruption, but then the court goes on to say that there was no evidence of substantial disruption occurring. The only evidence really was sort of the students who were a bit upset who came to the coach, and then the court notes that during the cheer coach's class, she was a teacher in the school as well, there was an interruption of about 5 to 10 minutes of class discussing these snaps. And the court says, well, that's not a substantial disruption. And there was no evidence that substantial disruption was likely to continue to occur or to occur thereafter. And so they can't say the suspension was being made to stop future substantial disruption, because essentially the coach testified in deposition that she didn't have any reason to believe this was going to cause major uproars continuing on into the future. And then finally, the last sort of issue that the school raised in terms of its justifications was one of team morale. And the court sort of notes that this could be a basis, but then gets into the idea that there is little that suggests that any serious decline in team morale to the point where it could create substantial interference in or disruption of the school's efforts to maintain team cohesion. So really, even in terms of that team morale issue, what we see is the court's looking back to this substantial disruption issue. So important takeaways. One, this was an 8-1 decision of the court. So it wasn't unanimous, but it's essentially as close to unanimous as you can get on this Supreme Court. There was a dissent filed by Justice Thomas. If anyone has read any of Justice Thomas's school opinions, you could see this one coming. Justice Thomas does not really believe in the rights of students and believes in the plenary authority of school districts to maintain discipline as they see fit. There were 2 justices who filed a concurrence stating that they agree with the court, but they have some different reasoning behind it. Justice Alito wrote that decision, and I actually have some pretty significant concerns with Justice Alito's decision because he focuses, I think, way too much on the in loco parentis issue. But that's a talk for another day when we have more time, if anyone really wants to nerd out on free speech. But there are some important takeaways that I think are really important in this case. Again, first, off-campus speech deserves more protection than on-campus speech. Your authority, if the student sends the snap out while at school versus when they're at the cocoa hut, is a big difference. Such speech is not, however, always outside of the school's interest to regulate. Off-campus speech would not include periods of time when the school is acting in loco parentis. So if you are in charge of that student, then that's not considered quote unquote off-campus speech. Off-campus speech may be regulated when it involves bullying, harassment, threats aimed at teachers or students, or involves the failure to follow curricular rules or the use of school equipment. So that again is pretty clear based upon the case that in those areas, the interests do still occur. Remember, it does talk about severe bullying or harassment, I believe, and then so we have to think about too when we're analyzing the severity, and that gets to this next point, which is off-campus speech may be regulated when it causes or is likely to cause a substantial disruption to the school environment. So that Tinker standard still does apply to off-campus speech. But I know this is an area that I've warned administrators about quite a bit. And I know I've sat through presentations that Kevin's done, and he's kind of talked about the same thing, which is that, it's not simply disruption. It's substantial disruption. And the school must be able to show that its action, and this is a quote from the court, where I believe they're quoting Tinker, which is that the school must be able to show that its action was caused by something more than a mere desire to avoid the discomfort and unpleasantness that always accompany an unpopular viewpoint. So it is important that disruption is substantial or likely to be substantial if we're going to act. Not every disruption is substantial. And I say that with the understanding that when you're a school administrator and you're in the middle of that, and this stuff's going on social media and these kids are talking about it, oftentimes everything feels substantial in that moment. But we need to really take a step back and analyze what it is we're talking about here and whether this disruption is substantial. Is this likely to lead to violence? Is it likely to lead to destruction of property? These sorts of things, or has it led to those things? Just because an activity is extracurricular does not put it outside of First Amendment protection. And I think that's an important piece, right? We have talked about in the past how there is no constitutional right to extracurriculars, and that's still the same. But we believe that I believe that's still correct when we're talking about things like due process, right? So due process is a constitutional issue for suspensions, but due process, isn't likely a consideration, or isn't one that the courts have found yet to apply to extracurriculars because there's no constitutional guarantee. But clearly the court is saying if you're suspending them from extracurriculars, you are you're taking action, and if that action is related simply to their speech, then that can be a violation of the First Amendment if it's not warranted. Now, one question I think that comes out of this and that we're going to have to figure out is, does the fact that it's extracurriculars impact the balance of what must be shown when considering whether the action is legitimate? In other words, how strong must the student's interest remain versus the school's interests? And the court doesn't give us much guidance there, but essentially, I think what's important is the majority doesn't differentiate the fact that this has come from an extracurricular. And clearly the court doesn't think much of the fact that she signed this, this letter on the team rules, because the court mentions it in talking about the basis, but doesn't mention it at all in its analysis. So clearly the majority court does not think there is much importance to that athletic code of conduct, which I know is going to have to adjust our thinking a little bit on some of these things. Another point that I think is important here, again, is the consistency in the enforcement of rules is important to the defense of a school's action. And again, this goes back to the point of, the vulgarity. If vulgarity is only important when we don't like the message because it makes our program or the coaches feel bad, then just relying on a statement relative to vulgarity isn't going to do a whole lot, because I'm sure this wasn't the only student who was ever vulgar, and you may know of a student or two who's been vulgar in the past. And as a result, if we're not enforcing those, it's going to get hard when we selectively enforce, and it's going to become part of the thinking when we deal with courts and the process. So that is the end of my section as well. Kevin, I will turn it over to you. If there are questions about this, again, we can get to it at the end. I don't want to take any more of Kevin's time away from him, though.
Yeah, no, thank you, Bob. I appreciate it, and really a great overview. And we could nerd out and talk about this for a couple of hours, and
for a long time. Yes.
Yeah, I suspect in the weeks and months ahead, particularly as the association conferences get back online, we'll be lining ourselves up to speak even in greater depth about this topic. But a great, fantastic overview. I don't want to say the best for last, and I certainly don't want to shortchange this very important topic. But your head, if it wasn't spinning from the COVID guidance, and then it was spinning from Bob's breakdown of that First Amendment case, I'm going to close strong and talk to you a little bit about Title IX. And I'm keeping my eye on the clock. I want to be mindful of everybody's time. We might leak a few minutes past 11, but really important, not only year that we've gotten through with respect to Title IX, but an important couple of weeks that we have seen. And so I will speak at a very high level in terms of what has happened really in the last year. And as I suspect everybody knows by now, the new Title IX regulations were announced last May, right in the midst of all of the chaos and people being at home and whatnot. They had an effective date of August 2020, August 14th, I think it was, because of course we were trying to get back to school in the midst of a global pandemic, and that's when the new Title IX regulations took effect. There was, between the announcement in May of 2020 and the effective date in August of 2020, a lot of litigation and legal challenges over the new regulations. Stated succinctly, the legal challenges didn't really go anywhere. They never really made any headway in terms of slowing down the new regulations. But why was there litigation? Probably a deep question, which we could talk about for a long time. But generally speaking, there were those who felt that the new regulations, which had been developed during the course of the Trump administration, were too pro-respondent and anti-complainant. And those are the terms that are spelled out in these new regulations. Complainant being the person who brings forward a Title IX claim, and the respondent is someone against whom a Title IX complaint is made. And there was a feeling by some, particularly victims' rights groups, that the respondent was being given too much deference in these new regulations. There was also concern about the very prescriptive nature of the regulations and just how much it was requiring educational entities to do. The new regulations are north of 2,000 pages. I will tell you that if you work at a university, they probably make sense. Very prescriptive, very process heavy. In the K-12 world, it was kind of like putting a round peg in a square hole. Certainly from an implementation standpoint, we have seen during the course of this 2021 school year, it's been very difficult, I think, not only to understand all of the prescription that has been spelled out, getting our policies updated, getting our regulations updated, not using a single investigator model anymore, having separate investigators, decision makers. There's lots of notice requirements, opportunities for the parties to review the investigator's report before a decision is made, so on and so forth. I won't go deep into the weeds on all of the regulatory requirements, but they are significant, and it has created challenges. What we have seen emerge, though, in the last 9 to 12 months is what I'm calling a new battlefield on this Title IX front. And we all know, generally speaking, Title IX prohibits discrimination on the basis of sex in educational programming and activities. And it is that on the basis of sex phrase that obviously we have talked about now for many years, but that really is where the battlefield has been for the last, like I said, 9 to 12 months, and where we're seeing these developments. And so very quickly, a timeline of notable events. Back last June, the last time the Supreme Court was churning out all of these significant cases, we got the Bostock case, Bostock versus Clayton County. And it's not a school case, it's actually an employment case. It doesn't have to do anything with Title IX. It has to do with Title VII. But what the Supreme Court held there was that Title VII has that same phrase, on the basis of sex, that we see in Title IX. And what they interpreted there in the employment context was that on the basis of sex included gender identity and sexual orientation. So that was a really big moment. Talk about landmark cases. That June 2020 Bostock case made it really clear that our Supreme Court believed that the phrase on the basis of sex was inclusive of gender identity and sexual orientation. Big impact in the employment world. And we looked at that case from a school perspective and said, well, golly gee, on the basis of sex, that's the same phrase we have in Title IX. We must also probably assume that Title IX covers gender identity and sexual orientation. As a practical matter, we sort of had assumed that was going to be the case, but we didn't really have the Supreme Court guidance. A few months later, the U.S. Department of Education put out an interpretation that said, look, we're aware of Bostock, and it doesn't specifically relate to Title IX, but yeah, we think probably that's how Title IX is going to be interpreted as well. November 2020, We have an election. Obviously, there's a change in administration. And as you get with changes of administration, often a change in approach and governmental philosophy. A couple of executive orders, one in January of 2021, which we'll talk about here in a second, and then another in March of 2021. And in between that, in February of 21, we had a big sort of national movement that was very focused on transgender females and sports equity. A lot of state legislatures, there was legislation advanced in the federal Congress aimed at this issue of not allowing transgender females to participate in athletics under the guise that it was detracting from equity, that it was not fair to biological females and denying them opportunities. We sort of still are dealing with that debate. There's been a lot in the papers even recently. And then just here in the last couple of weeks, a U.S. Department of Education statement, which we'll talk about. And then just the other day, the Supreme Court denying cert in the Gavin Grimm case. And so what does it all mean? Clearly, the focus under Title IX in the last handful of months has been, what are the rights of LGBTQ individuals? How are we supposed to treat them as it relates to Title IX? How are we supposed to operate now under the guise of this Bostock case that we have gender identity and sexual orientation being covered? So I referenced the two executive orders that were issued by the Biden administration, and one came right after inauguration. The EO on preventing and combating discrimination on the basis of gender identity and sexual orientation. And the key sentence to be extracted from that is children should be able to learn without worrying about whether they'll be denied access to the restroom, the locker room, or school sports. That's a pretty definitive statement as to what the administration's view was going to be as they move forward into their term in office. A few weeks later, we got the EO guaranteeing, which I think is an important word, guaranteeing an educational environment free from discrimination on the basis of sex, including sexual orientation or gender identity. And what that EO did was direct the Secretary of Education to consult with the Attorney General to review all existing regulations, orders, guidance, documents, and other similar agency actions that are or may be inconsistent with administration policy. So what that was is, after Miguel Cardona was confirmed as the Secretary of Ed, that was the administration saying, go through everything, and we want to make sure that everything that the U.S. Department of Education is putting out from a guidance perspective is consistent with our administration policy. What is our administration policy? It's very, very clear. And I'm not here to offer a political commentary on it, but it's very, very clear based on that EO that we got in January, that children should be able to learn without worrying about being denied access to the restroom, locker room, or school sports, in a position that guarantees an educational environment free from discrimination on the basis of sex. We thought, okay, sort of in early predictions when we saw those EOs, well, look, there's some things that they can do, but going in and changing the administrative regulations that really took the Trump administration 4 years to implement was going to take time. And so there were certainly things that they could do from a U.S. Department of Education standpoint, but you can't change administrative regulations overnight. It takes some time. So what we have seen then in the last 3 months is what I'll say sort of is a battle for headlines. And you see the way this issue, this paradigm is changing and being addressed on different fronts. And so in Michigan, Michigan was not immune from the deluge of bills that were brought forward on this gender equity issue. Both the Michigan Senate and a House bill to divide high school teams based on biological sex. Again, we saw this countrywide. I think it was 36 different state legislatures brought bills forward, all within a 3 or 4 week period. Again, I'm not here for political commentary or editorial, but let's be honest, what's going on? What's going on when Republican legislatures are bringing these bills forward? They're doing it because they think they have an issue they can win on. They didn't all wake up in February and March and decide to have these bills. They see the landscape, they see what's happening, and they advanced these bills in a very coordinated way, again, both federally and on the state level, because again, I think politically they think they have an issue they can win on. And so I will report, as of yesterday, neither of the Michigan bills had moved at all, other than being introduced. 2 weeks ago, June 16th, the U.S. Department of Education confirms officially in a notice of interpretation that Title IX protects students from discrimination based on sexual orientation and gender identity. And so the earlier August pronouncement that, yeah, that's probably the case, interpreting Bostock. Now they come out in mid-June with an absolute declaration, a notice of interpretation that says this is what it's going to be, and this is how we are going to enforce it, and this is how we are going to interpret it. About 8 days later, Department of Ed announces that their proposed Title IX rule changes are expected by May of 2022, and that such changes are going to be, and you gotta love this quote, consistent with the priorities of the Biden-Harris administration. And so what we suspected in our early predictions was going to happen is happening. They're going to go and look at those rules, and I suspect if I were to opine, perhaps in a different forum, what the new rules are going to look like, I think they're going to be probably less respondent friendly. That has certainly been the criticism, and I would be surprised if they did not provide more flexibility, particularly in the K-12 setting from a procedural standpoint. For those of you who have been through a Title IX investigation or process during the course of this school year, if you followed the new framework, it's really, really cumbersome. It is time consuming, it is very difficult, and I would be very shocked if when the new rules are introduced in May of 2022, we didn't get some relief from a K-12 standpoint. More headlines. Same issue going on in Michigan is going on in Ohio. Ohio Governor Mike DeWine made a comment last week that transgender athlete issue shouldn't be resolved by the government. His position is that local state high school athletic associations should be able to make decisions on that front, or individual leagues, individual schools, so on and so forth, and that it shouldn't be legislated at a state or federal level. That debate rages on. And just if we didn't have enough, just the other day, Monday, the U.S. Supreme Court announced that it will not hear a transgender bathroom rights dispute, which is deemed a win for the Virginia student who sued his school for discrimination. Many of you have heard the name Gavin Grimm. It's a transgender male. His battle with his school, Gloucester County Schools, goes back several years now, including a prior trip to the Supreme Court where certiorari was denied. The case has been going on for a long time. Supreme Court has said they won't hear it. What is the significance of that? The significance of it is that that then affirms the decision of the Fourth Circuit Court of Appeals, which was very much pro-student. The other thing I think it tells us definitively is that our Supreme Court is going to agree with the Fourth Circuit interpretation that Title IX is inclusive of gender identity and sexual orientation. So that is what the Fourth Circuit had ruled. The Supreme Court doesn't want to review that case. And I think that is very consistent with what we have talked about and what we have assumed the case would be. But now our Supreme Court has given us additional ammunition to bolster that interpretation. So a big couple of weeks here when we look at Department of Ed's notice of interpretation, their intent to revise the rules, and then the Supreme Court rejecting the school district's appeal in the Gavin Grimm case just on Monday. And so in terms of moving forward, holy cow, Kevin, what do we do? What are the expectations? The expectations are that we're going to follow the law. And as Kathy sort of alluded to on her practical guidance slide, that's sometimes easier said than done, and things do change quickly. We know that regulatory changes are coming from the Biden administration, and we're going to have to follow the very prescriptive Title IX regulations that we have for now. Until there is some intervening authority, and there's a reason that the Trump administration did them as regulations, so they couldn't be easily dismissed, they couldn't be easily discarded or set aside. It's going to take time. So we're going to be stuck, I think, for at least one more school year with this very, very prescriptive, cumbersome, protocol-heavy process in terms of doing Title IX investigations. As it relates to other things, making decisions about how to support LGBTQ students, I want to say nothing is really going to change, because we've been counseling clients for the last several years to support students on the basis of their gender identity, on the basis of their sexual orientation, to not stigmatize, to not draw distinctions. And so our guidance really is not going to change very much. I think it's going to go the way we thought it was going to go. You might say, well, wait a minute, I sort of read accounts, or I had heard that maybe the Trump administration hadn't been enforcing that so vigorously, and that's true. Under President Trump, the U.S. Department of Education Office for Civil Rights was not, stringently enforcing bathroom things and other LGBTQ student issues, but the federal courts were. And so even during the 4 years of the Trump administration, we saw a whole bunch of federal lawsuits that came out in a very pro-student posture. And so we think that is just going to continue. And clearly that is the direction of the Biden administration and what they have put into action, again, now bolstered by our U.S. Supreme Court. So a very quick update and snapshot. Yeah, I will just say that if you have not, and obviously last year was insane for everybody, if you have not looked at your Title IX regulations, if they have not been updated to reflect the new expectations that were implemented last year, that's something you should use the summer to do. I know it's time for rejuvenation and relaxation, but I do think if you haven't done that work, you're going to need to do that work, because we're going to be stuck with those, I believe, for at least another year before we see a change. And so if you haven't had a Title IX grievance, I think that's wonderful. Hopefully you continue that string of good luck. But eventually the bill always comes due, I suspect, and everybody will see these at some point. You want to make sure you have those processes and procedures up to date. With that, we get to three really good-looking people there, and that gets us to the end. Let me ask Bob and Cathy to maybe turn their mics back on and join me. Do we have anything in the Q&A that we haven't dealt with yet that we need to clarify?
Yeah, I do have one question that I wanted to address to the crowd, Kevin. But first, you said last year was kind of crazy. I hadn't noticed that. Was something going on? What?
Yeah, right. No doubt.
No, the question that was in the Q&A says, Bob, would you then suggest that schools that have athletic student policies or handbooks that regulate off-campus speech should remove those requirements as they're no longer legally binding and put us at risk? Now, Kevin and Cathy, you can please feel free to jump in on this one, but I would say no to that as a general statement. We're probably going to want to look at them. We're going to want to think about what it is we're really preventing in those handbooks. We're going to want to think about our enforcement of them, because I think if you're going to be put at risk, where that's going to happen oftentimes is in one of a couple scenarios, right? You have one coach who's really hardcore about some of this stuff, and other coaches who are laxed, and what that looks like in terms of the enforcement process. Or again, you have one coach maybe who has thinner skin than another and only really enforces when it criticizes them. And let's again be honest, right? If students criticizing coaches when they're outside of practice or games is a long held tradition of high school students. So, I mean, I think we really need to think about, I wouldn't say a blanket, no, don't have them. But I do think we want to take another look at them in light of Mahanoy and think about what it is that we're trying to prevent and how we want to phrase it.
Yeah, I guess, Bob, I agree with you. And I would say maybe two thoughts on that front. I mean, one, it's almost as if, and I know they didn't address it, but it's almost as if the court felt like the language in the athletic code or the rules, the cheerleading rules, were almost an unconstitutional restriction on free speech, right? I mean, that'd be one way you could interpret maybe their silence on it or their ignoring of it. I don't know that I certainly wouldn't want to draw that conclusion. But I think, secondly, to your point, there's lots of things that we do that we don't know if they'll be legally enforceable, but we still do them. For example, and the one that comes to mind are, permission slips, and what really amount to pre-injury waivers, which, not getting us down a rabbit hole, aren't technically enforceable for minors under Michigan law. We still have them, people sign them all the time. We have people sign permission slips to go on field trips, to go to events and whatnot. And whether at the end of the day, those things are ultimately legally enforceable is an open question, but we still do it. And so I agree with you that I wouldn't go in 86 our expectations as outlined in the extracurricular codes of conduct. I'd make the student and their parent and their attorney make the argument it and convince a court and not just concede and withdraw.
Right. And I think, one of the issues, and I know, again, this is one of these topics that is really sort of, it's only been a week since the decision. And so I think a lot of lawyers within our firm and outside of our firm who deal in school world are still mulling over what this all means. Right. So like, as an example, if instead of being suspended for a year, a student is denied the captaincy because of some statements they've made online, or other sort of privileges like that. What does that mean? Now, if you think about, First Amendment, generally the idea is either you're violating or you're not. You can't violate a little bit, right? Right. So maybe that doesn't matter, or maybe it changes the balance of interests and things that we're thinking about. So, I think there's a lot still to work through on this. And I think if you have some questions, reach out to one of us or somebody else or your lawyers to talk through, your specific code, I would say.
Yeah. Cathy, anything to add?
All that too. And I guess I would add, to what Bob said, I saw a little bit of a distinction in that case between privileges and granting, playing time or, captaincy and that sort of thing versus denying, discipline and taking things away. And so I think there may be some room there for those types of things too in a policy.
Yeah.
Absolutely. Well, I see it looks like our Q&A and our chat are clean. So with that, I'll put up our information on our resource center for those that are interested. But we thank everybody for joining us. Everybody has earned the month of July off. I hope everybody gets a chance to relax. Hopefully it stops raining for a couple of days and we can enjoy some sunshine. But wish everybody a wonderful summer. Have a great, hopefully an opportunity to relax and get ready for another school year, which I'm sure will be enthralling and exhilarating and interesting. But we thank everybody. The video of the webinar will be available later today, as Amy said in the chat. So if you want to share it with any of your colleagues, it will be out there for consumption. Bob and Cathy, a pleasure as always. Thanks so much, everybody. Have a great day.
Thanks, everyone. Happy summer.
Everybody.